The DMCA, otherwise known as the Digital Millennium Copyright Act of 1998, was signed into law to protect the rights of copyright holders and to prevent copyright infringement. It was an amendment to Title 17 of the United States Code because the pre-existing legislation did not address technology's interference with copyright infringement. Copyright infringement is the copying, redistribution, or downloading of software, music, videos, or games without the copyright holder's express permission to do so. The Internet allowed users to freely traffic music, text, and other digital property without copyright holders' permission. The Internet also made it faster and easier than ever before to download patent digital content. Copyright holders felt that the laws currently in the U.S. legislation did not provide enough protection of their work. Therefore, the U.S. signed 2 treaties that offered more protections to international copyright holders and also addressed technology issues to keep copyright safe. These treaties, the WIPO Copyright Treaty and the WIPO Performances and Phonographs Treaty, was signed in the U.S. in December 1996 and ratified by Congress. The DMCA was only the beginning of Congress's evaluation on the relationship between technological change and U.S. copyright law. In conclusion, DMCA was the foundation of an effort by Congress to implement U.S. treaty obligations and move the nation's copyright law into the digital age. Compared to the normal legal process for when a person imitates your non-digital copyrighted material, the DMCA protects digital copyright material via takedown notices. A takedown notice is fast, simple, and can be drawn up by a copyright holder without the help of a lawyer. A DMCA takedown notice only contains a few pieces of information and there's no set format. Basically, you write a letter requesting that the OSP remove or block the offending page. Safe harbor laws in the DMCA were provided by Congress to create a series of safe harbors for network service providers. The term safe harbor is actually a nautical metaphor, indicating a place where a ship will be safe from stormy weather. But in the case of digital copyright, DMCA Title II creates a safe harbor provision which protects Internet service providers from the consequences of their users' actions. Since the DMCA became law in 1998, there have been few court cases that have interpreted its language.
As an example of how the copyright law contained in the DMCA affects how we access copyrighted material, let's look at YouTube.com. Under the DMCA, YouTube is considered to be a service provider that qualifies for the safe harbor provision. This means that YouTube is not responsible for any cases of copyright violation on its network. In order to qualify for safe harbor protection, YouTube must not have knowledge of or financial benefit from any infringing activity on its network. It must also have a copyright policy and provide proper notification of that policy to its subscribers. It must also list an agent to deal with copyright complaints. So when a rights holder sees an act of infringement on the website, they are able to contact this agent. YouTube does all of this, and so are able to qualify for the safe harbor provision. When there are cases of copyright infringement, the rights holders are supposed to issue takedown notices to the users who uploaded the content, and the legal responsibility then falls to the user or uploader. So again, to clarify, when infringing material is uploaded, YouTube as a service provider is not violating copyright law. According to the DMCA and the safe harbor provision, it's the users who are. However, some copyrights holders, including corporate media giant Viacom, are unsatisfied with this aspect of the DMCA. They believe that service providers like YouTube are in fact violating copyright law. And in 2007, Viacom sued YouTube for $1 billion in damages in the court case YouTube versus Viacom. In response to this, YouTube and its parent corporation Google created a system called Content ID. The Content ID program is a database containing hundreds of hours of copyrighted material. It uses an algorithm that screens material as soon as it is uploaded by a user. If the uploaded content matches any of the copyrighted material in the database, it gets flagged as infringement and is immediately removed from the website. This is before even the rights holders know that the material has been uploaded. The system is not foolproof or necessarily ethical. There are times when videos with infringing material are not successfully matched in the Content ID system and are not removed. There are also complaints from YouTube users and rights holders themselves who claim that the uploaded material, even when copyrighted, is never assessed for its potential fair use value under copyright law. This would allow the material an exception and allow it to remain online. To test the Content ID system, at the end of this video we will be playing the song by Prince entitled Raspberry Beret. It is copyrighted material, and in accordance with copyright law and the DMCA, we should receive a takedown notice, or the video should never be uploaded to begin with.